All right, the next case in our docket this morning, the final case, is 23-2094, Florida Roads Trucking et al. Versus Zion Jacksonville LLC, and so on. Counsel, you prepared to proceed?
Yes, Your Honor.
Please approach.
Thank you, Your Honor. May it please the Court?
And would you like to reserve any?
Reserve 5 minutes for rebuttal, Your Honor.
Thank you.
This is an arbitration case. I represent Florida Roads Trucking, CAPS Land Management, and Marugan Trucking. We're just going to call them the trucking companies today. My name is Kurt Kohler. I'm with Cole, Scott, and Kassane. So in this case, we have two elements of the arbitration, of the three elements of arbitration at issue. The first being whether there's an agreement, and the second being whether there's an arbitrable issue. So on the agreement issue, there's 2 points. First, we're arguing equitable estoppel, because our clients were not a signatory to the agreement. However, they are alleged in the complaint that there's a concerted action between them and the main signatory of the agreement, namely Archer Western.
So on equitable estoppel, would you agree that it is a correct statement of law that equitable estoppel cannot be used to expand, alter, or diminish the terms of the arbitration agreement?
Right, so that's the second issue, the terms of the agreement. So equitable estoppel gets you to the point where you're in the door, but you still have to comply with the agreement itself, which in this case says any controversy or claim of buyer against seller or seller against buyer. So the other side is arguing that this is limited strictly to the buyer and the seller, and I believe the surety as well of the buyer.
You concede that your clients are not the buyer, not the seller, not the surety.
However, we are the subcontractor of the buyer, and we're the assignee of those duties under the contract from the buyer. So under that premise, we can apply equitable estoppel, because there's a concerted action here alleged in the complaint, namely paragraphs 127 to 133.
So you concede your clients are not one of the parties that's listed in the agreement, but the argument is that they are the subcontractor.
Right.
Can you give me your best case for the proposition that a subcontractor, for lack of a better word, can stand in the shoes of one of the parties to the arbitration agreement, and therefore it's not expanding the scope of the arbitration agreement? What's your best case for that?
That would be Cone Construction, I think. I don't have the site with me, but I can submit that if you want a supplemental afterwards. But that,
I assume you're referring to the case in the briefs, right? Not a new authority here, or?
I'm not sure. I don't know that one's in the briefs, but I think that there is in the briefs case law stating that an assignee can apply equitable estoppel.
An assignee?
Yeah, assignee, and the subcontract is an assignee of the buyer for those duties under the contract regarding trucking.
Right. Now, if they're the assignee of those duties, however, are they also the assignee of the rights that were conferred in the arbitration provision? Is that your position?
Yes, they would be.
Okay. Because just by operation of law, or by a
case
provision
law
of the contract, or the provisions of the particular subcontracts?
It'd be by operation of law, yes. It would come back, by operation of law, the arbitration agreement applies to assignees.
Okay. Can you speak a little bit to the Beck Auto Sales case?
Yes.
And tell us why we should view your case differently.
Right, so Beck Auto Sales does not involve a subcontractor. In that case, you had an employee of there were two dealerships. So the first dealership, where the employee previously worked, they alleged that she was trying to disrupt a contract with Tallahassee, between that dealership and Tallahassee, to sell cars. And then she went to work for the second dealership, which was Beck. So in that case, you don't have a contractual relationship between Beck and the first dealership and the employee. Beck is not related at all to that. So they're not a subcontractor. They're not an assignee. They're just another party out there. And there was a dissent in Beck as well, which found that that arbitration was appropriate.
And could you also speak a bit to the status as precedent of Beck, given that it is a first district case, and of course, you know, the operative facts in this case arose before the realignment of the districts. So at the time that this conduct occurred, right, the parties were at that time governed by first district case law. Would your position be that we should look to Beck as persuasive but not binding authority?
My position would be it's persuasive at best, and that you can consider a dissent in Beck.
Okay, so...
And if you find the dissent persuasive, then you can rule in that direction.
Okay, so your position is we're not bound by first district case law, notwithstanding the fact that this occurred pre-realignment, for lack of a better term. Okay, so in terms of fifth district case law, is there something that you would point us to as most closely analogous? Do you think that we're writing on a relatively clean slate? It seemed like the fifth district case citations were sparse.
I think it's a fairly clean slate. The other cases I've seen were from the third DCA. And I think it was the third DCA. So I believe that you would have a relatively clean slate on that. As far as the second issue, arbitrability, that was addressed in a previous oral argument last week. In the case 23-1784, it's essentially the same issue presented there as here. And essentially what we're arguing there, that this is broad language in the arbitration clause, that there's a jury waiver, and right above the arbitration clause, there's a separate clause that has a jury waiver, and that there's a significant relationship between the claim and the agreement as far as, we have two claims here, trespass and the litter law claim. So the contract does say that the parties are required to comply with the law. There's a clause on appendix number 129 requiring the parties to do that. That's an attachment A. But in addition to that, the idea here, I think it's in the Variella case that was submitted as supplemental authority. If you're required to construe the contract or consider the contract, then you would have a contractual nexus. And for both of those claims, you have to do that because the contract determines what, they're essentially arguing that they exceeded the scope of the contract. So you need to consider the contract to determine what the scope was. And you have to construe it to determine what the scope was, both for the litter law issue and for trespass. Because otherwise they were permitted to be there for the purposes of the contract. It is only if they exceeded it that there would be a claim.
Now, a contract, though, would be void for public policy, would it not, were it to authorize violations of at least the litter law? Would that be a valid contract? So if the contract says, yeah, you can, visit on this property for the purposes of, removal and excavation of sand and also, dumping materials that would violate Florida statutes, wouldn't we look at a contract like that and say that it would be void insofar as it purports to authorize a violation of
Good, but
Florida
you still have to
statutory law?
construe it as to what it says. You still have to consider it. This isn't like the other types of claims in other cases where there's really no relation between the contract and the claim. For instance, the Variella case, it was a Florida Civil Rights Act about, I think it was a pregnancy issue. And in that case, there just wasn't any connection between the employment contract or partnership agreement and the claim. It was just completely separate. Here, there's a connection. You have a clear connection between what is required by the contract and what these claims are saying is they went beyond that and did things they weren't authorized to do. Otherwise, there would be no trespass. Otherwise, there'd be no litter law violation. Well, obviously, if they didn't do it, then there wouldn't be a litter law violation. But they're required to comply with the law under the contract, and litter law is a state law. So you have to construe the contract for both the litter law and the trespass in order to decide these claims, and therefore it's arbitrable.
So if a contract says, you have a duty to comply with the law, that brings in a lot of matters that are pretty extraneous. I'm just trying to envision that do you have a limiting principle for that? Or is it, well, you've got a duty under the contract. Yes, your law-abiding, duties arise from two sources, right? They arise from statutes, they arise from the contract, but those things are separate. But is it your position that if The contract requires you to abide by the law and the law independently, regardless whether you have a contractual duty to comply with the law or not. The law independently requires you to comply with the law. That's still going to be swept in. What's the limiting principle there?
I think the limiting principle is that this has to have some relation to the contract. So we end up back really where we started with a contractual nexus. So you have to be either construing or considering the contract for this to be arbitrable, and our position is that that is required for these claims. There's no way to decide them without doing that, without considering the contractual scope of what they're allowed to do there, which was they were assigned the duty to truck the A3 sand out, and whether they exceeded that or not is a matter of contractual interpretation. You have to consider the contract here.
They weren't contracted to haul anything in,
Right.
and that's the allegation.
That's the allegation,
There's under
yes.
no description in the contract does it contemplate bringing material back onto the property.
That's correct.
So you're saying just because trespass ordinarily involves traversing across a property, that's enough to take it into the terms of the contract, even though what they were doing by coming back on the property, arguably they were supposed to be coming back on the property with an empty loading bay of the truck, yet they were bringing material which wasn't contemplated in the contract at all back on the property. You say that still means that it was contemplated based upon the terms of this contract.
That's the allegation, but you still need to look at the contract to know what they were allowed to do, and then by implication what they were not allowed to do under the contract.
And there was nothing describing bringing any material back onto the property by the trucking companies, correct?
I think that's mostly correct. There might be nothing on the scale that's alleged in the complaint, essentially. So there might be some, I only hesitate because there might be some minor issue there, but in general, that's correct. So I also want to talk about, I think that with regard to Seifert, again, I think we've pretty much covered everything that I was going to present in the initial segment, and I'll reserve the 5 minutes for rebuttal.
Okay, counsel.
Good morning. May it please the court. My name is Niels Murphy, and Andrew Brigham and I are here for Appellee Zion Jacksonville LLC. There's really two issues, but I'm going to focus on the primary one, as my colleague pointed out. Is there an agreement to arbitrate? And the law is clear. I mean, it's pretty rare that we have a case on all fours on this very issue, and that's what Judge Anderson addressed, and that's the Beck case. And that's a two-phase analysis, right? We know that the trucking companies are not parties to the agreement. They did not sign the agreement. Archer Western, which was the buyer, and our client, Zion, as the seller, were the only two signatories to the agreement.
Before we get all the way into Beck Auto Sales, could you speak to the question I asked your friend on the other side about, whether we view Beck as persuasive authority or binding authority, given sort of the oddities about the realignment, the conduct that's alleged in the complaint having taken place before the realignment when it was then governed by First District case law? Do you have a position on that? Does your client have a position?
I do, and it was actually fodder for discussion at our dinner table last night. It's an interesting question. It's an excellent question, and I do think that the Beck applies here, and it should be binding. The Beck case is out of the First District Court of Appeal. At the time of the conduct at issue, at the time that these claims arose, at the time that we asserted these claims, the first DCA precedent controlled this piece of property, which is one of the most valuable, pristine properties in Northeast Florida, in the First District Court of Appeal. The Beck court set the rules. They set what's the standard. And that standard should carry over to the Fifth District Court of Appeal, even though I know technically nothing is binding. Certainly, it should be much more precedential, not only because it was in the first DCA and it controlled that parcel of property, but also because it is the only case directly on point.
Sure. So what I'm hearing is binding not in a strict sense, right, as a sort of, stare decisis sense, but binding in a sense of maybe just basic fairness is what I'm hearing, right? So it seems like, though, you would concede that, that now that Duval has joined the 5th District, we have the authority to set what constitutes 5th District precedent, even for cases that arose before the realignment.
I think you do, but I think it would be akin to changing the rules in the middle of the game, right? When the Zions own this property and enter into contracts and their conduct, they should be allowed to rely on the law that applies to that piece of property at that time. And so I think it would be unjust and unfair to say, okay, now that we've had a realignment of the district courts of appeal, that somehow now that prior law that applied to them all of a sudden does not. So I think it is fair to assume that the Beck case did apply. And that two-phase analysis, right, the first thing you have to decide is, right, okay, do you even get to look at the arbitration clause? And here, let's concede that they do get to look at the arbitration clause. As was set out in Beck, you still have to strictly construe the arbitration clause itself. And
Sure, and your friend on the other side, it sounds like, is distinguishing Beck on the basis that he alleges that the trucking companies are assignees of the contract, and including the contractual right to compel arbitration. Could you address that point specifically?
Absolutely. So I think, well, first of all, Beck is not the only case. It is the only case in the First District Court of Appeal, but there's also an 11th Circuit case, the Chroma case, 11th Circuit Court of Appeal, a federal case that is spot on and agrees with Beck and also lays out this exact same procedure. And in fact, there's another case, a Coakley case, which is the first DCA case, which predated Beck, which also lays out this procedure. And then...
Now, that case, I think, allowed enforcement of the arbitration, but under some peculiarity about it, like an agency relationship.
Yes,
right, between the parties.
and yes, as to your question, the Beck case is super clear, right? You have to look, you have to strictly construe this. And this contract says buyer and seller. And it doesn't just eliminate third parties altogether, it also mentions the surety. So there was consideration of those specifically identified parties. The trucking companies are not mentioned anywhere in the contract. So unlike some of the other cases where, particularly in the Coakley case, where if you read the Coakley case, the third party non-signatory actually signed the contract on behalf of the signatory and was doing the work. So,
but are those subcontracts assignments?
Well,
would you agree with that characterization? That seems like your colleague
I don't
on the other side.
No, I don't agree that there's an assignment. I've never seen an assignment. There's no assignment in the record. I've never seen an acknowledgement or a recognition by my client that this was assignable at all. The contract should be strictly construed. It doesn't mention the trucking companies. It doesn't mention them by name. It doesn't even mention them in concept.
Does it mention a right to assign rights and duties under the contract?
Well, maybe the right to assign, but there is no assignment. There's no assignment in the record before this court. The only thing before this court is this contract between Archer Western, and as we know and is alleged in the complaint, Archer Western has their own trucks. They're one of the largest construction companies in the world. They own a whole fleet of trucks. There's no presumption on the part of my client that they're going to subcontract this, that they're going to use third-party trucking companies. So you have to look at the strict language of this arbitration clause, and it's super clear, Judge Pratt, as you pointed out. This says any controversy or claim of buyer against seller or seller against buyer or its surety. This is not parties or intended third-party beneficiaries or assignees or others, it doesn't say that. It is very, very specific, and we know that the seller is Zion and the buyer is Archer Western. What we also know is the buyer is not the trucking companies. So as set forth in the Beck case, which is, again, directly on point, it says basically that an equitable estoppel only allowed Beck to access the arbitration clause, but it did not expand the scope of the disputes subject to arbitration. The plain language of the arbitration provision was expressly limited to disputes, and Beck was not a party. Therefore, disputes with Beck fell outside the arbitration clause. And there's a direct quote on page 68 of the Beck opinion that basically sums this up and why it's important, that application of equitable estoppel could address the Beck dealership's non-signatory status, effectively counting it as a signatory, but it would not expand the scope of disputes subject to arbitration. Although Florida law, like federal law, favors arbitration, it is still true that no party may be forced to submit a dispute to arbitration that the party did not intend and agree to arbitrate. Therefore, even when a non-signatory can rely on equitable estoppel to access the clause, the non-signatory can compel arbitration only if the dispute at issue falls within the scope of the arbitration clause. And the scope of the arbitration clause is a pure matter of contractual interpretation. And they go on to say, another direct quote, at bottom, the Beck dealership was not a party to the arbitration agreement. So disputes with it fall outside the general scope. And if you look at these several other cases, the Beck case, the Chroma case, and the Alabama Supreme Court case, which is really what was relied on in Beck and the Coakley, the Alabama Supreme Court was spot on. It actually, in the case that's cited in Alabama, the words were buyer and seller, the exact same words that are in this arbitration clause. And the Alabama Supreme Court said, if you're not a buyer and you're not a seller, you don't get the benefit of the arbitration clause.
And counsel, you're saying the First District relied upon the Alabama case?
Yes, the First District Court of Appeal relied on the Alabama Supreme Court case in Parkway. Absolutely cited it.
Was Beck discussed in the trial court?
Yeah, absolutely. In this trial court, yes,
right.
Beck was the primary basis for Judge Anderson's ruling against the trucking companies. In fact, I have a quote from Judge Anderson in paragraph 34 of his order. He said, similar to the findings and holdings in Beck, in the present case, the court finds that none of the trucking companies were party to the arbitration agreement, and as such, disputes with the trucking companies fall outside of the arbitration agreement's general scope.
Now, if the trucking companies were driving onto your property to deliver the sand and someone was injured from the trucking company and they went to sue you, you wouldn't try to arbitrate that, would you?
Well, I think that's not in the record. I think that the key issue here is they came onto my client's property.
Yeah, but my question is, if they come onto your property and they are injured by something that is alleged to have occurred on your property, are you going to force them into arbitration?
Well, I don't know what my client would decide to do, but presumably they'd like to use the court system. And what did happen here is these trucking companies, as is in the complaint, they came onto this property and they dumped sludge, concrete, asphalt, rebar, wood, tires, and metal strapping. Not only did they do that, they dug holes around a 900-acre parcel of land, and then they buried it, and then they covered it with white sand. And then when they got caught red-handed, there was no disclosure of where they buried it. What happened was an 18-month treasure hunt with us having to hire experts to go find where they dumped it. So as to the second issue about whether or not there's a substantial relationship or a nexus, absolutely not. The only two claims against the trucking companies are violations of Florida's litter law. They dumped garbage on my client's property and destroyed the value, and they trespassed for that purpose. They had no authorization, as Judge Wallace pointed out, they had no authorization to be there for that purpose. There was certainly never the intent. I don't think any court could look into it and say that the intent of Zion was to allow people or to contemplate that conduct would happen. And so the relationship between that conduct and those claims.
I think we understand the point. Typically when parties contract, they're looking for one man's trash to be another man's treasure, not another man's trash. So I understand that, but your friend on the other side mentions that there is a provision in the contract that requires compliance with the law. Could you speak to that just briefly about your perspective?
Well, the first thing I want to point out is he kept coming back, my colleague kept coming back to the point that, oh, there is a contract, so we have to look at it. Well, in every arbitration case before this court, there's always a contract. And the Florida Supreme Court found specifically in the Seifert case that just because there's a contract doesn't control the substantial relationship or the contractual nexus. And I agree with Your Honor's point, Judge Pratt, that if we're talking about a statutory claim, which is litter, that has nothing to do with a nexus or significant relationship. And compliance with general laws, we all have that obligation. I don't care whether you put it in the contract or not, right? The presumption is that you're going to follow the law, and you don't need to rely on a contract for that purpose. So I would submit that by putting it in the contract doesn't somehow turn this into an arbitrable issue. That's something that should be presumed as part of every contract, that you're going to follow the laws of the state of Florida, the United States. So again, I come back to the two real issues here. One is, which differentiates this case from the case that was argued last week. The issue here is the trucking companies were not a party to the contract. They do not get the benefit of the arbitration clause or other provisions in the contract, even under the theory of promissory equitable estoppel. Because even if you say there's equitable estoppel, they don't get it because by its own terms, the contract doesn't include the trucking companies. That's issue one. And then issue two is this issue about this substantial nexus, right? Even if you found all of those things, you'd still have to find a substantial nexus or a contractual nexus or substantial relationship between the conduct that's alleged here and the contract to sell A3 sand. And it's just not there. And you know what? This is probably the first case I've ever, we have pictures. The pictures that are in the record show there's no substantial relationship between dumping garbage and burying it and hiding it on our property and the sale of A3 sand. You don't need to look at the contract to make that determination. And if there's no further questions, we would rest on our briefs. Thank you.
Thank you, counsel.
We ready?
Proceed.
All right. I want to go back to what our best case would be. I think that would be Coakley, and that's a first DCA case. So that's going to be my answer there. That's from the briefs. It's been raised. We're going to rely on that. As far as Beck, that's not on all fours. It's a different situation. You had a situation where that employee that was not, the second dealership was not in contract at all, not a subcontractor, not an assignee with the first dealership. So that's not on all fours at all. It's a different situation. The court shouldn't apply it. Secondly, as far as the issue of the subcontractor status, we address this again as far as what an assignee is. I'm just saying that a subcontractor is an assignee of certain duties under the contract. So we're not getting into anything other than that. They admitted in their complaint that our clients are subcontractors. They didn't use the word assignee in the complaint.
Sure, but so just the formulation there, that they're the assignee of certain duties. It seems to me that you're seeking to enforce a contractual right, not a contractual duty. So is your position that the subcontracts assign not just duties under the contract, but also certain rights under the contract?
It does assign the arbitration right as well. I was just referring to the duty to haul and to truck.
I see.
So I wasn't trying to make any broader point there. I'm just going with what the contract says as far as the immediate things they were hired to do. But I do believe that arbitration is a right that you can enforce on an assignee and an assignee can enforce. And in this case, it's subcontractor.
Now, is that provision assignable given that it is so specific that it encompasses disputes between seller and buyer's surety?
Yeah, I think in this case, my clients are going to stand in the shoes of the buyer by virtue of the assignment and subcontracting. So it isn't just the words in the contract, it's also who gets to stand in their place. And in this case, the trucking companies get to stand in the shoes of the buyer for purposes of the arbitration clause. And that's the position we're going to hold to. So, and that's just general assignment law. As far as, let's see, there's anything else. And again, we're not here on the merits, we're not here on the maps or the allegations, we're just here on the arbitration clause. So I don't have much to say about the allegations of the complaint other than that you have a contractual nexus here between those allegations and the contract. So you're going to have to construe the contract to rule on the trespass and the litter law violations. It isn't just like a general law anymore because you had some authorization for them to be on the property and you had authorization for them to dig. You have to determine from the contract where they exceeded that if they did. And if there's no further questions, my clients will rest on their briefs, and thank you very much for your time.
All right, thank you to both councils. We will be in recess till this afternoon at 1 o'clock.